From local stories to Wayne County news, get ready to dive into everything happening in North Carolina with Taylor House Publishing. Got a story to share? Shoot us an email at taylorpublishinghouse@gmail.com. If you're looking to publish your book or need some top-notch mentorship, we've got your back. Join the excitement with the one and only Richard Taylor, right here at Taylor House Publishing. Speak with Richard directly at 919-587-7782. Don't forget to smash that like button, hit subscribe, and invite your family and friends to watch.
From Wayne County to the Carolina coast, Taylor House brings the news you love most. Tune in on YouTube, don't miss a beat. Little stories that keep you in your feet.
Taylor House, we got the school.
Taylor House Publishing.
Bobby Paul Burke, 27 years old, nicknamed Jamaican Bobby, was sentenced Friday in Wayne County Superior Court to life in prison for murdering Patrick Joseph Luton Jr. in July of 1991. Jurors deliberated more than 2 hours before returning a verdict shortly after 7 p.m. Before the verdict was read, Judge Russell Duke cautioned the audience that he would not tolerate any outburst of emotions in the courtroom. Despite the warning, supporters of Burke could be heard crying softly. As jurors affirmed their decision one by one, Burke frequently glanced back at his sobbing girlfriend, finally breaking down himself. Before sentencing Burke, Duke asked him if he had any final words to say to the court. A sobbing Burke said, "I'm deeply sorry about that lady's son," referring to Anita Luton. "But at the same time, I'm losing my kids too, and my family as well." Duke then offered Miss Luton, who was also in tears, a chance to address the courtroom. "I realize my son is gone for the rest of his life. One day he, meaning Burke, will get out, but my son will never return, and I'm asking for the maximum penalty," Miss Luton said. Prosecutors had decided not to seek the death penalty in the case. Burke's defense attorneys, Gene Hollowell and Shelby Albertson, said they plan to appeal. In closing arguments, prosecutor Claude Ferguson told jurors to weigh all the evidence presented in the case, but not to stray from the fact that Luton was dead. "When you think about this case, I also want you to think of Joey Luton. Joey Luton was murdered because there were drug dealers on Maple Street who decided to take his life," Ferguson said. Witnesses said Burke was sitting at a fire hydrant away from the crime scene sometime between 5 and 6 p.m. Burke, says from about 5 o'clock until the time of the killing, he was sitting there for 6 or 7 hours just thinking. It must have been a coincidence that the place he was hanging out happened to be this drug area, Ferguson said. They try to paint the idea that Mr. Burke was so cooperative. It's interesting that he did come in the police station for fingerprinting. It's interesting that nobody's fingerprints were found on the steering wheel, including Mr. Luton, who was driving the truck, Ferguson said. Police found Luton's body on the floor of a pickup truck parked on Oak Forest Road. He had been shot twice in the back. Investigators said they believe Burke acted in concert with Jamaican Ricky, a suspect law enforcement officers have not been able to locate. Burke was considered the most wanted fugitive in Wayne County for more than a year. He was apprehended in February by authorities in Washington, D.C. on drug-related charges. Now, what you just read was an article from December the 12th, 1994. And I came across this article today at the library while doing some research for another story. And I thought it was interesting because back in the early 90s, in the late 80s in Goldsboro, but also across the United States, was the crack epidemic. And during that time, there was a lot of lawlessness in the streets. But among those lawless people were a group of immigrants or Jamaicans. Back in the day, there was a lot of Jamaicans coming from Jamaica, but a lot of around the country, there were several who were involved in the drug trade. Now, I read a book called The Shower Posse by Vivian Blake, who was a Jamaican immigrant and who detailed, how the Jamaicans and his organizations were all up and down the East Coast. And they actually mentioned where I was staying at when I read the book, Norfolk, but they also mentioned, North Carolina. I think he mentioned Goldsboro in the book. So when I was coming up in 1991, I was 13, but I always heard those names: Jamaican Ricky, Jamaican Bobby, Jamaican Tony. But at that time, I wasn't quite yet off the porch. But those, names always held a mystique. And so I decided to dive into this article and research the case. And I'm going to give you some information on this case. And that information is going to come from justia.com, which is going to go over Jamaican Bobby's appeal in 1995. Now, this crime allegedly happened in 1991, and he was convicted once again on December the 12th, 1994. Now, the names that you are going to hear, some of the names that you may hear in this article may be familiar, but I just want to dive into this just to give the public, some details about some of the events that you may have heard about, but, you don't have any details. Now, mind you, this is from Justia U.S. Law. So this is the information that the courts had related, not saying that this information is true or false, but these are the information that was cited in the defendant, Jamaican Bobby Paul Burke. And I'm going to put this information on the screen. You can read along with me. But in this appeal, Jamaican Bobby cites 6 areas where the court may have erred in convicting him. And so this is the evidence, this is the result of that appeal, with the courts upholding the conviction and denying his appeal. Now, mind you, he was sentenced to life. That was in 1994. So I'm not sure, he may or may not be out, depending on, some of the statutes back then. But once again, some of this information is, is very interesting, as it details the crime, certain people who were involved in the, or not involved, I'll say, that were mentioned to be in the area where this crime took place. Now, you can read along with me. The defendant, Bobby Paul Burke, was tried non-capitally, and a jury found him guilty of the first-degree murder of Patrick Joseph Luton. The trial judge imposed a mandatory sentence for life imprisonment. Defendant was also convicted of 1 count of discharging a firearm into an occupied motor vehicle, but the judgment was arrested on this conviction. On this appeal, defendant made 6 assignments of error. We conclude that the defendant trial was free from prejudicial error, meaning he made some claims of how the trial court may have erred in his conviction. But it says here, the Supreme Court of North Carolina denied that those claims. So let's read further. The state's evidence at trial tended to show the following facts and circumstances. In the early morning hours of July the 26th, 1991, Patrick Joseph Luton and John Wright drove to a section of Maple Street in Goldsboro, North Carolina, where it was common for drugs to be sold in the street to people in their vehicles. Among the drug dealers on Maple Street were a man called Jamaican Rick and the defendant, known as Jamaican Bobby. Wright, a frequent purchaser of drugs, had been to the area earlier in the evening of July the 25th, 1991, with a person whose wallet had been taken either by Jamaican Rick, James Big Deal Prelo, or Chevy. Now, they're detailing a lot of the scenes in the early 90s where you can be on the block, you can be, I think, I'm not sure if this area was in Fairview, you can be on North End, you can be on Slocum Street, you can be anywhere, and people would drive through and you would look them in the eyes and you can tell if they wanted drugs, and then you run up the car and sell the drugs. So evidently, I don't know if Mr. Luton and Mr. Wright were smokers or were they people who bought drugs for resale. But evidently, this incident details that one of the men's wallet were taken by either of the three people mentioned in this statement. And so let's read on. It says, later, during the early morning hours of July 26, 1991, Luton drove Wright back to Maple Street in a borrowed truck to get the wallet. While they were stopped on Maple Street, the wallet was given to Wright by Big Deal. Wright observed the defendant standing near the truck with a dull-colored automatic handgun. As Luton drove away, Jamaican Rick yelled that he had been ripped off. At that point, Jamaican Rick and another black male began shooting at the truck driven by Luton. Now here they tell you that, they went back to get the wallet. The wallet was given back. And then Jamaican Rick yelled out that, he had been ripped off somehow. And then two black men, as they said, opened fire. They said Jamaican Rick, and then they said another black male began shooting at the truck. Now, Luton was struck by 2 bullets. Wright immediately pulled the truck to the side of the road, left the truck near the scene of the shooting with the key in the ignition, and ran home. The truck was found later that morning several miles from the Maple Street near the trailer park where the defendant resided. Luton was found in the truck, dead from 2 gunshot wounds. A lead cord that could have come from a .44 caliber gun was found in the descendant's abdomen. Also, parts of 2 9mm bullets were found under the floorboard and behind the seat of the truck. Now, this paragraph said that when Luton was shot, Wright got out of the car, ran, and later the truck was found in a trailer park by where they said Jamaican Bobby stayed at. Now, on the floor was a part of a .44 caliber bullet and 2 9mm bullets, meaning there were 2 guns that were shot at Luton and Wright. And so the article continues, says 4 days following the shooting, the Goldsboro Police Department received an anonymous tip that evidence could be found in a dumpster near the location of the shooting. On July the 30th, 1991, Goldsboro police searched the dumpster and found a shoebox containing a .44 caliber handgun and 2 boxes of .44 caliber ammunition. The gun, which is number 215 in evidence, holds 6 rounds and 3 bullet casings in it. The defendants, meaning Jamaican Bobby, fingerprints were on the boxes of ammunition. The defendant admitted that he had owned a .44 caliber handgun and had bought the ammunition for himself and Jamaican Rick. So now we have somebody close to the situation informing the police where the murder weapon and the bullets were. And this has to be somebody close because, they knew exactly where the murder weapon and the bullets were. And so they found them, but they also found Jamaican Bobby's fingerprints on one of the boxes of ammunition, which once again, he admitted that he owned a .44 cal and had bought ammunition for he and Jamaican Rick. Now, since it was undisputed that Jamaican Rick was one of the shooters, the major disputed issue at trial was the identity of the second shooter. The state presented testimony that the defendant was the second shooter. Although the defendant did admit that he was present at the scene of the murder, he presented evidence through his own testimony as well as the testimony of others that suggested that someone else was the second shooter. So now, In the trial, they knew that Jamaican Rick was one of the shooters, but now Jamaican Bobby is presenting evidence that not he, but there was another individual who was the second shooter. Now, this is his first claim of how the trial court erred in convicting him. It says, for the first defendant's first assignment of error, he contends that the trial court erred in refusing to allow him to present evidence that would show that Big Deal was at one time considered a suspect in the case. First, the defendant argues that it was error to refuse to admit defense exhibit number 3. Defense exhibit number 3 consisted of a set of Big Deal's fingerprints that was taken by the Goldsboro Police Department. This set of Big Deal's fingerprints, along with one set of the descendant's fingerprints, was meaning John Luton, the man that was killed, and 2 sets of Jamaican Bobby's fingerprints, who was the defendant, was given to the state fingerprint expert for use in trying to find a match with any fingerprints lifted from the evidence submitted to the SBI crime laboratory. The trial court did not allow the fingerprint expert to testify that the defense exhibit number 3 was a set of Big Deal's fingerprints taken by the police department and did not admit the exhibit into evidence. So now this is what, Jamaican Bobby's defense tried to do at trial. Evidently, Big Deal's fingerprints were taken by the police, along with the dead man's fingerprints and also the defendant's fingerprints. However, those fingerprints were not admitted into evidence. And this non-admittance to Jamaican Bobby was an error because he feels like that, those fingerprints may have matched up with evidence collected by the crime lab, namely the box of ammunition or the handgun. He also tried to mention that Big Deal was a suspect in the case. Now, he further contends, the defendant, that the court erred in not permitting Ronald Melvin, a Goldsboro police officer, to testify that he had listed Big Deal as a suspect in the case at the time he submitted various items of evidence to the SBI crime laboratory. Defendant contends that the excluded evidence, defense exhibit number 3 and Officer Melvin's testimony, corroborated defense testimony that Big Deal, not the defendant, was the second shooter. Defense testimony showed that the .44 caliber gun pulled from the dumpster was the same one Big Deal carried the night of the murder. Defendant argues that since the only issue at trial was the identity of the second shooter, the evidence that Big Deal was a suspect points directly to Big Deal as the second shooter. As such, the evidence is highly probative in that it implicates Big Deal while exonerating defendant. The court says, we disagree with the defendant's contentions and conclude that the trial court did not err by refusing to admit this evidence. So basically, once again, the defense of Jamaican Bobby is trying to say that since Big Deal was listed as a suspect initially, and also he was said by defense witnesses to have been carrying the gun that was found in the dumpster, that it was he, not Jamaican Bobby, that did the shooting. But this is what the court says. The court said that the court has held that a defendant may introduce evidence tending to show that someone other than defendant committed the crime charged, but such evidence is inadmissible unless it points directly to the guilt of the third party. Evidence which does no more than create an inference or conjecture as to another guilt is inadmissible. And then they list certain case law. So what they're saying is just because, he could have been carrying the gun and also he was listed as a suspect does not necessarily point to evidence that he committed the crime. So therefore, that evidence is inadmissible. And they further go on to explain exonerating Big Deal in this case. In this instance, the court admitted evidence that Big Deal was present at the scene of the crime and that Big Deal was carrying a .44 caliber handgun that night of the shooting. However, the evidence that Big Deal was a suspect is not probative of whether Big Deal committed the crime, and that it does not show that Big Deal was the second shooter. Being a suspect in a police investigation does not necessarily implicate the suspect in that it is not evidence that the suspect is guilty of a crime. Accordingly, the evidence that Big Deal was at one time considered a suspect does not directly point to the guilt of Big Deal, nor does it exonerate the defendant, Jamaican Bobby. As such, the trial judge did not err in refusing to admit the evidence. So, but basically they just said is, although you're saying that he had the gun and, he was considered a suspect, that does not mean that he did it. You admitted to having the gun, you admitted to buying the gun and buying the admission, and other witnesses have implicated you in the crime. So just the fact that you're saying that, Big Deal had the gun does not equate to his guilt. So Mr. Big Deal was exonerated in being implicated by Jamaican Bobby and his defense team. Now, the second assignment of error, Jamaican Bobby and the defense contends that the trial court erred in admitting state exhibits 28 through 35. Among the items introduced into evidence by the state were a shoebox, a .44 caliber handgun, 2 boxes of .44 caliber ammunition, a spent cartridge from the gun, and 3 bullets found in the gun. All of the exhibits were found in a dumpster 4 days after the shooting and 2 days after the defendant was interviewed by the Goldsboro police. Defendant contends that there was no connection between these items and the murder, and therefore the exhibit should have been excluded. The court disagreed. So what Jamaican Bobby's defense team is saying is that all of the evidence, the gun, the bullets, the ammunition, the bullets found in the car, none of that should have been admitted because they don't have anything to do with the crime. However, the court disagrees. And in their explanation, it says, in order for the evidence to be admissible, it must be relevant. The test of relevancy of evidence is whether that it has the tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without evidence. Basically, they're saying this finding of this evidence makes Jamaican Bobby more guilty than less guilty, or the crime more probable to have happened than not having happened. Now, once again, the trial court admitted contradictory evidence as to who was carrying what type of gun was presented at trial. One witness testified that Jamaican Rick had a .44 caliber handgun similar to the one found in the dumpster, and that he was carrying that gun on the night of the shooting. However, 2 other witnesses testified that Jamaican Rick was carrying a 9mm handgun the night of the shooting. 2 other witnesses testified that Big Deal was at the scene of the crime carrying a .44 caliber handgun similar to the one found in the dumpster. Another witness testified that the defendant was carrying an automatic weapon the night of the murder, but the defendant admitted to police that he owned a .44 caliber handgun. So there you have what they're basically saying here. There's a whole bunch of stories contradicting each other about who had what type of gun. Normally in this situation, that is what happens. When something like this happened, people don't tend to tell the truth about what really happened. And once again, this is information given to the court by the appeals court. So not saying that any of this information is true or untrue, but this is what was discussed at court. Now, this is the court's ruling about the relevancy of the evidence. The evidence in question is relevant because it tends to link defendant to the crime, thus allowing the jury to infer that the defendant was the perpetrator of the crime. From the fact that a 44 caliber handgun was found in the dumpster, along with a box of 44 caliber shell bullets linked to the defendant through both his fingerprints and his own testimony, the jury could infer that it was the defendant who fired the 44 caliber handgun the night of the murder. According to the state's evidence, the bullets found in the dumpster were consistent with the type of bullets recovered from the victim's body because the evidence was probative on this question of the defense's guilt and could be used to connect him to the crime. The trial judge did not err in admitting this evidence. What he's saying is, okay, the defendant admitted to owning the 44 caliber handgun, to buying boxes of bullets. The boxes of bullets held his fingerprints on it, and the bullets found in the car were consistent with the box of bullets that held the defendant's fingerprints on it. Therefore, they did not err in admitting the bullets, the gun, the ammunition, and all the other evidence found in the dumpster. And so, the third error that the defendant tried to point out, he said that the defendant contends in his third assignment of error that the trial court committed reversible error by refusing to allow him to inquire into statements made by Corey Best. Two witnesses, Cortisha Williams and Sanita Williams, stated that the defendant was one of the shooters. At trial, defendant presented testimony that Cortisha and Sanita left the scene after Cortisha had an argument with Corey Best, but before the shooting occurred. To corroborate this testimony, defense counsel questioned Calvetti Johnson during the trial. The following exchange took place between defense counsel and Calvetti Johnson. So now what they're saying is, the defense is saying that two witnesses stated that Jamaican Bobby was the shooter. However, Jamaican Bobby, along with Mr. Johnson, contends that these girls left the scene after having an argument with one Corey Best, so therefore they could not have seen who was the shooter. And so now what you're going to see is the defense or the prosecution questioning Mr. Johnson on the stand. What did you see? His answer: well, it was nothing but a fuss. Mr. Burke and Corey Best was fussing, and Corey Best went on Edgerton and got a gun and came back, and he ran Cortisha and Sanita off and told them if he caught them over there again, what he would do. What did he say he would do? Well, he said he would, and the prosecution objected. And then they objected because this would be hearsay. And so they went to the bench, as you see, and they had a discussion. And then the witness was permitted to answer. He stated meaning Corey Best, said that the best I can recall, if he caught them back over there, he would kick their little asses. He would do this and that. And so, as you see in the next paragraph, the defendant asserts that had this comment been received into evidence, the jurors could not have inferred that such a threat would have motivated the girls to leave, thereby corroborating testimony that they had already left the scene at the time of the shooting. So what the defendant is saying is that they did not let Mr. Johnson's statement saying that he ran the girls off and, telling them not to come back. They did not let the jury hear that statement. So the defense says that if the jury would have heard that statement, they would have known that the girls could not have been there to testify to see who was shooting. Nevertheless, the court did not allow that error. Now, the defendant contends that the statement was admissible because it was not hearsay. It is well established that if an out-of-court statement is being offered for any purpose other than that of proving the truth of the matter asserted therein, it is not objectable as hearsay. In the instant case, defendant was not offering the statement to show that the declarant was going to hurt the teenage girls, but to explain why Cortisha and Sanita had left the scene before the shooting. Therefore, the trial court erred in excluding the testimony. Once again, he's saying, look, y'all should have let that statement go through. But the court says, however, the error was not prejudicial. It is well settled that no prejudice arises from the erroneous exclusion of evidence when the same or substantially the same testimony is subsequently admitted into evidence. Several witnesses testified that Cortisha and Sanita were not at the scene during the shooting because of an argument between Cortisha and Corey Best. Calvetti Johnson testified that he witnessed Corey Best getting a gun and running Cortisha and Sanita off the street. Defendant and other witnesses, Rico Lewis, also testified that they had seen Cortisha and Corey argue, after which time Cortisha and Sanita left the scene. Therefore, the defendant was allowed to present this evidence through other testimony and was not prejudiced by this error. So what they're basically saying is they didn't let that statement go, but other witnesses testified that the girls had left and they were not present at the scene. Now, the fourth assignment of the error, and we're going to go through this because these are, just technical issues. The fourth assignment of error, defendant contends that a trial court committed reversible error by refusing to allow defense counsel requests for second counsel. 1 week prior to trial, defendant moved for the appointment of Shelby Dufford Albertson as additional counsel. Defendant appointed counsel Gene P. Hollowell had represented him for 8 months, but defendant asserted that additional counsel would materially assist the preparation of the case because of the number of potential witnesses who have been listed by the state and the existence of other potential witnesses. In support of the motion, defendant argued that the case was complicated and would take over a week to try, and the state was advantaged by 2 assistant district attorneys being assigned to the case. The trial court, citing Ms. Hollowell's 10 years of experience, denied their motion. Therefore, Ms. Albertson, Ms. Hollowell's law partner, gave a notice of representation and participated in the case without appointment. Therefore, defendant contends that the trial court's failure to appoint additional counsel showed its bias towards the state and caused an unfair advantage. For the state, we disagree. But he's basically saying is, look, I got a lawyer, but I need 2 lawyers because of all the witnesses, all the complications of this case. Now, the state had 2 district attorneys, so the defendant is saying that I needed 2 lawyers. However, the court cited Ms. Hollowell's 10 years of experience, but also they allowed Ms. Albertson as well to join with her as, a non-appointed lawyer. So, and another, and I'm just going to paraphrase these. His fifth assignment of error, defendant contends that the trial court committed reversible error by refusing defense counsel requests for sequestration and individual voir dire of the jurors. Now, meaning he's saying that, all these jurors have to be sequestered, meaning held in a hotel, not being able to watch the news, because this trial received a lot of publicity. And with that publicity, he feels like he couldn't get a fair trial because the jurors may be prejudiced by all the media coverage. And then the court says the defendant has not argued or shown that the trial judge abused his discretion in not allowing individual voir dire or sequestration of the jury. He simply argues in his brief that individual voir dire is necessary in any case where there has been pretrial publicity. A defendant does not have a right to examine jurors individually merely because the trial has been there has been trial publicity. And then they said that the last one, he said that the jury was prejudiced because of prejudicial comments made during the trial. Now, also, that request was denied by the courts. So all in all, what you just heard was the breakdown of the appeal of the case of Bobby Paul Jamaican Bobby Burke, who was, a player in the game here in the early 90s in Goldsboro, North Carolina, and his appeal. Now, I do not know if he is still incarcerated, so we're gonna do a real quick search here and see if he is still incarcerated. Of course, I should have did this before the video, but let's see. We're gonna search, and at the time he was 27 years old. So today, 27, 37, 47, 57, he would be almost 60 years old, if my math serves me correct. Now, I just checked, and there is nothing that shows that he is currently an inmate anywhere in North Carolina. So we would have to conclude that he may have been released, or he may have been deported. That is also an option. So, but nevertheless, once again, those names, and the reason, once again, why I did this story, because I came across it, and it was, very interesting to see this article. And if you see the article, you can't really see it's black and white, but he's actually crying in the video. And it says he's reacting to sentencing, but he did receive a life sentence. And, there are certain consequences to come when you're involved in that lifestyle. And as I mentioned, in the early 90s, a lot of people were involved in those things, and a lot of people lost their lives. A lot of people went to jail. A lot of people lives were negatively affected by the crack era, whether it's, parents getting strung out on crack, children, having to fend for themselves. That was a very tough time, in certain challenging communities. And so I remember those times. I remember those names. So I just wanted to dig a little deeper in this, in this case. And once again, this information was given by Justicia U.S. Law. And this is information that was is public and was stated in trial. So this is just a public discourse about a case that was very notable in the early 90s. Now, I don't know whatever happened to Jamaican Rick. I don't know. I think he got killed. I'm not sure. Y'all can let me know in the comments. And also, once again, Jamaican Bobby, I don't know whether he is still here or he was exported or deported. And I think there was another guy named Jamaican. There was a lot of Jamaicans around in the early 90s. They were coming in, as I told you about the book written by Vivian Blake called The Shower Posse. That's a great read. That's one of that gave me some insight on these things. But I'm pretty sure that, he actually mentions Goldsboro in North Carolina in that book. And so I'm not sure if these are the players that he mentioned in his book, or were they part of his organization. But the Jamaicans, as you saw in the movie, were Marked for Death or Hard to Kill with Steven Seagal in the late 80s. You saw the Jamaican drug gangs. You know what I'm saying? So this is an example of the Jamaican drug gangs right here in North Carolina. So I just wanted to revisit that. I was surprised to see it, as I was researching on the microfilm. And but yeah, so I hope y'all enjoyed this case. All of the information, once again, is public record. So any names brought up, it was not to disparage them, but it was also just to give some insight on this case. But peace and blessings. Y'all have a blessed day. 919-587 7782. Thank y'all for tuning in. Make sure y'all like, share, and subscribe to the channel. Peace and love.
587-7782. Don't forget to smash that like button, hit subscribe, and invite your family and friends to watch.
From Wayne County to the Carolina coast, tell our house, bring the news you love most. Tune in on YouTube, don't miss a beat. Local stories that keep you on your feet.
Taylor House, we got the scoop.
Taylor House Publishing.